Welcome to the Divorce Lawyers podcast, brought to you by DivorceLawyers.ca, where we delve into the complexities of family and divorce law, providing insights and guidance for those navigating these challenging times. Today, we're tackling a crucial topic: avoiding high-conflict cases with collaborative practice. I'm Deepa Taylor, and in today's episode, we'll explore how collaborative practice can offer a more peaceful, efficient, and effective alternative to traditional litigation, helping families avoid the destructive path of high-conflict court cases. High-conflict cases are characterized by intense, ongoing disputes where the parties involved are often entrenched in their positions, leading to prolonged legal battles. These cases are emotionally and financially draining, not just for the parties, but also for their families. In Ontario, we've seen numerous instances where couples have spent years in court, with some even becoming what we call tenants of the courthouse, appearing dozens of times without resolution. This is exactly what we want to avoid. So, what makes these cases so difficult to resolve? Often, it's a combination of deep-seated emotional issues, a lack of communication, and a desire to win rather than find a fair resolution. These factors can lead to a cycle of litigation, where each side becomes more entrenched, making it harder to reach an agreement. Collaborative practice offers a different approach. Instead of battling it out in court, the parties and their lawyers commit to resolving the dispute outside of the courtroom. This process is based on open communication, mutual respect, and a shared goal of reaching a fair and sustainable agreement. The collaborative process begins with a participation agreement, where both parties and their lawyers agree to work together toward a resolution. This agreement also includes a commitment to transparency and honesty, key elements that are often missing in high-conflict cases. If the collaborative process breaks down and the case goes to court, the collaborative lawyers must withdraw, ensuring that everyone involved is fully committed to finding a solution. One of the most critical aspects of collaborative practice is screening, assessing whether the case is suitable for this process. Not every case is a good fit. For instance, if one party is unwilling to negotiate or listen to the other side, collaborative practice may not be effective. During the screening process, we look for red flags, such as a history of domestic violence or an unwillingness to compromise. We also assess whether the parties can work together with the professionals involved, follow through on tasks, and genuinely engage in the process. Screening also involves evaluating the lawyers and other professionals involved. Collaborative practice requires a high level of trust and cooperation, not just between the parties, but also among the professionals. If there's any indication that the process might break down, it's better to identify that early rather than risk further conflict later on. So, why choose collaborative practice over traditional litigation? One of the main benefits is control. In collaborative practice, the parties maintain control over the process and the outcome. They work together to find solutions that work for their unique situation, rather than having a judge impose a decision. Another significant advantage is the emotional and financial savings. High-conflict cases can drag on for years, consuming vast amounts of time, money, and emotional energy. Collaborative practice, on the other hand, is often quicker and less expensive. It also helps preserve relationships, which is especially important when children are involved. By reducing the conflict, collaborative practice can lead to better outcomes for everyone, particularly the children who are often caught in the middle. While pure collaborative practice is highly effective, some cases may benefit from a hybrid approach. This involves combining elements of both collaborative practice and traditional litigation. For example, certain issues might be resolved collaboratively, while others, such as disclosure disputes or third-party involvement, may require court intervention. In a hybrid model, the collaborative process is still the focus, but the court is used as a tool to resolve specific issues. This flexibility allows for a tailored approach that meets the needs of the family while keeping the case out of the adversarial court system as much as possible. I've seen firsthand how effective collaborative practice can be. For instance, one case involved a couple who had been in litigation for over 2 years, with no end in sight. Both parties were exhausted, both emotionally and financially. We decided to pull the case out of court and try the collaborative approach. Within weeks, they had reached an agreement that worked for both of them, a resolution that had seemed impossible during their litigation. Another example involved a high conflict case where one party wanted to apologize to their former spouse. This simple act of communication allowed them to move past their differences and focus on resolving the financial and custodial issues. This kind of outcome is rare in the courtroom, but common in collaborative practice. Of course, collaborative practice isn't without its challenges. One of the biggest obstacles is the initial resistance from one or both parties. People often enter the process with doubts, especially if they've been in litigation for a long time. However, once they experience the benefits, being heard, having control over the process, and working toward a mutually beneficial solution, those doubts often dissipate. It's also important to address the potential downsides, such as the risk of the process breaking down. However, with proper screening and a strong commitment from all parties, these risks can be minimized. The key is to ensure that everyone understands the process and is genuinely committed to making it work. To wrap up, collaborative practice offers a powerful alternative to the traditional adversarial court system. By focusing on cooperation, communication, and mutual respect, it helps families avoid the destructive cycle of high-conflict litigation. If you or someone you know is facing a divorce or family law issue, I encourage you to explore whether collaborative practice might be the right path for you. For personalized guidance, please consult one of our family lawyers by visiting DivorceLawyers.ca. Thank you for joining me on this episode of the Divorce Lawyers podcast. If you found this discussion helpful, please subscribe and leave a review. And as always, if you have any questions or topics you'd like us to cover in future episodes, feel free to reach out. Until next time, take care.